Hello everyone and welcome to today's Mondac webinar in association with OA Legal, who will be outlining the key developments of the Swiss legal framework on tokenization. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Fabian Gillios is a founding partner of OA Legal. Fabian has a long-standing and broad experience in providing corporate advices to Swiss and international clients, ranging from entrepreneurs and SME companies to regulated businesses. He is specialized in corporate commercial law and data protection regulations. He also assists fintech companies on Swiss financial laws and regulations. Alexander de Rocard is also a founding partner of OA Legal. Alexander advises Swiss and foreign financial institutions such as banks, securities firms, fund management companies, asset managers of collective investment schemes, asset managers of individual portfolios, financial advisors, companies active in the offer and marketing of financial products, as well as fintech companies on Swiss financial laws and regulations. Before we begin today's webinar, a quick housekeeping item. You can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and the panel will endeavour to answer as many of your questions as possible during our Q&A session. It's now my pleasure to hand you over to Fabian and Alexander to begin. Thank you.
Thank you, Dan. Hello, everyone. Thank you, Mondac, for inviting us on this webinar. So the topic we will discuss today is the tokenization of real-world assets, and we will focus on the Swiss regulatory framework allowing the issuance of securities token and also the possibility to trade them on a secondary market, a regulated one. So basically, you can move on the next slide. So we will discuss first the Switzerland ecosystem on the fintech side, why Switzerland, and also on Geneva, what are the opportunities and what has been done for the Swiss security side for fintech activities, and namely DLT project, blockchain project. We also discussed what we call the financial, the Swiss authority, FINMA, for the market authority, which has issued some guidelines on the issuance of tokens, which is quite a pillar of the regulatory framework in Switzerland. And we will discuss also the tokenization, basically of real-world assets and mainly financial instruments such as shares, as bond, obligations, and we will see other also kind of instruments. And when an issuer wants to do an offer to the public to acquire securities, you need to have a prospectus requirements. And my colleague Alexander de Rocard, who is going to take the lead afterwards, will explain you what are these requirements for prospectus, and we will also develop the secondary market regulation we just discussed. So we can move on to the next slide. So as I said, in Switzerland, it's quite known to be a favorable regulatory environment towards what we call distributed ledger technology, such as blockchain and indeed cryptocurrency and fintech activities. Because back at the time, in 2017-16, there was a lot of projects who issued some tokens, and they provide a lot of hope to all the holders of the tokens, saying we develop a nice platform, we can use it, and please buy our tokens. And basically, people were, it was just a scam, and people went away with the money. So the Swiss Financial Market Supervisory Authority, the FINMA, which is a regulator in Switzerland, said this is enough. Now we will issue some guidelines on what we call the initial coin offering of those tokens, and that has set some rules, and we will explain this in more detail afterwards. And this is one of the pillars that mark the regulatory framework for all the activity in fintech since then. And in September 2020, the Swiss Parliament passed also what we call the distributed ledger technology. It's a DLT Act, and basically is not a new law that has been passed, and actually it's one of the fastest law that has been passed that we know in Switzerland, because it has only adapted 10 existing federal law. Because what is interesting in Switzerland is that we have a flexible regulatory framework. The code of application is quite flexible, and the FINMA is technology agnostic, so they don't care about the technology. So we just need to adapt some of the provision in the code of obligation, in the financial laws as well, and in the insolvency law. So that was more easier and smoother to adapt this distributed ledger technology, and we will go through this DLT Act afterwards in more detail as well. So there was some other amendments, but it will take another webinar to explain to you all what has been done. But those are the pillar that has put Switzerland as an international pioneer for the innovative financial market technologies. Now on the Geneva side, basically, there is quite an innovative ecosystem also, because there are the following key components. You have a local, private, and government support. So basically, the Geneva state, few months after the issuance of the FINMA guidelines, has issued its own guidelines on ICO to tell all the people how they're going to treat this token or this token. And they provided some guidance on how the Geneva will also tax those tokens. And they added on top of it an interactive mapping of all the relevant actors in the DLT sector. So basically you have accounting firms, you have tax experts, you have law firms, you have banks, you have KYC AML provider, and there is a mapping of all the actors within this the ecosystem of Geneva. So if you need someone, you just go on this mapping and you find the right person. And what is interesting also in Geneva is that you have a Rue du Rhône, where there is basically all the family offices, banks, and asset managers and individuals who are also keen to invest in fintech companies. So basically for fundraising, it's usually good to be next to your investor who are interested in this kind of technology. And Geneva has a broad I say a line of investor for that. And there is a lot of also synergies with national and international academics researchers. Basically, we have done training with the Lyon Academy for smart contracts, for smart legal contract, and this is something which is very very keen for the academic to reach out to them as well. And some example of well-known actors in Geneva, there is the company back at the time, which is called Montpellerin, who was the first company who has ever tokenized the shares of his company and put them on the blockchain, and actually now is tradable as well. And they were the first in 2018 to do that. And there is also what we call the Capital Market Technology Association, which is the association, we will talk about this in more detail as well, who is providing some standard for the issuance of securities token and also accounting and technology at the technology level as well. And finally, we have a company called Taurus, who this year, and maybe also this is the reason why the timing of this webinar is because this company has obtained from the FINMA, so it's a regulated trading venue, the right to open their secondary market to retail investors and not only institutional for digital assets and securities token, which I think, from what we know, is the world premiere. We can move on to the next slide. So, as I said, we will discuss a bit the FINMA guidelines. So in 2018, the Swiss regulator has issued those guidelines, and I think it's the first one who did that. And not only they just said how they're gonna, they clarified some legal framework on the ICO, but they provided a detailed analysis on how they intend to treat the initial coin offering. And also the first time that a regulator has classified tokens. So we know that the SEC is now struggling to qualify whether it's a security, it's a payment, utility. But in Switzerland, since 2018, the set of rules are clear. And the practice of the FINMA is clear on that. So classification of token, you have a payment token, a utility token, and what we call an asset token. And we'll go through that to explain you also on each token, what is the regulatory framework applying to them, securities regulation, if it applies, or an AML regulation as well, to see how it applies. And what is also interesting in Switzerland is that not only these guidelines give you the detailed analysis on how the token will be treated, but the FINMA provided an annex where you can issue a non-action letter with 24 points you need to raise to explain to the FINMA, and you can ask the FINMA to obtain a ruling on the qualification of your token. So it gives you a certainty that there will not be any enforcement of the FINMA provided you do things correctly afterwards. But legally speaking, you can ask FINMA to obtain a ruling on the qualification of the token. And so we'll go through that as well. And as I mentioned, the Geneva State, with their guidelines, has also clarified some tax status on the issuer of the tokens. So we can move on this next slide. So as I mentioned, there is first the payment token. So the payment token is an easy one. It's a mean of payment that is used for acquiring goods or services. And basically, it's what we call more the cryptocurrency. And the most famous one, we would say, is the Bitcoin. And I don't know how it is in your jurisdiction, but I think it's commonly now recognized, even in the US, that now the Bitcoin is not a security, it's a cryptocurrency. So in Switzerland, it's quite easy. It's a cryptocurrency, and it's just a means of payment. For now, next slide, the utility payment, the utility token, sorry. The utility token, the definition on the guidelines is a token that is intended to provide access to an application or a service by means of a blockchain infrastructure. So if you're using the token to access to a service of a platform, you will likely fall under the definition of a utility token. That's for the definition for the moment, and then we will explain how the rule apply to those tokens. And basically, just for the record, we will focus more on a securities token, but it's important to have the three kind of definition to understand what is the line between a cryptocurrency, a utility, and a security token. And finally, we arrive to the asset token, and the asset token is a token that represents a claim against a company, the issuer, such as debt or equity, basically share, bonds, and any kind of capital flows and claim against a company again. And in terms of economic function, any kind of token that are analogous to a share, bonds, or a derivative, or whatever it is, like such as royalties, will fall under the definition of an asset token and basically a securities token. There is at the end of the paragraph of the guidelines, a final definition on the asset token, which is a token that represents a physical asset, what we call the hard asset here, which is on the asset token definition. But the weight, it depends how the weight is construed, it will not likely be considered as a security, but we will discuss this also later on. And the FINMA also explained in its guideline that a definition or qualification of a token is not mutually exclusive. So you can have a utility token that can be also a payment token, or can be also an investment token or a securities token. So it's not just one token. Okay, it can be both, or even three different kind of qualification. So if we go on the regulatory side, and for the payment token, the FINMA explained that the securities on the securities side of a regulation, payment tokens are not treated as a security. This is clear. You don't have to have a prospectus requirement to issue a payment token, for securities regulation, I mean, right? And the FINMA said that if the case law or legislation would evolve, FINMA might revise its practice, but since 2018, payment tokens are not securities, okay, and it won't change in the near future. Now, for the AML, you can go on the next slide. For the AML regulation, one who issue a mean of payment under Swiss law is deemed to be considered as a financial intermediary. So as such, the Anti-Money Laundering Act require this issuer to be affiliated to what we call a self-regulatory organism, SRO, or be submitted to the supervision of the FINMA, but this is a bit too hard, and to be affiliated to a self-regulatory organism, this is enough. And it's not like an authorization, it's just to be affiliated to this SRO, okay, self-regulatory organism, who will be supervising your AML, your AML duty if you have done things correctly or not. And usually you need to have also auditors on the AML who will just check whether all the AML requirement has been met. Now, what is interesting, you can move on the next slide, is that the FINMA guidelines say, okay, if we ask all the issuer to be affiliated to a self-regulatory organism, then we will not facilitate the issuance of tokens. So they put an easement, they added an easement, but is not backed by law. It's just the FINMA practice, which says that an issuer of a token, if they accept the funds via a third party who is himself affiliated to an SRO, the issuer does not have a duty to be affiliated himself. Okay, and that has facilitated a lot at the beginning the issuance of token, because people were using a third-party service provider and is still using now today a third-party service provider who are themselves affiliated to this SRO. This being said, now the FINMA has been a bit restrictive because we have obtained a lot of rulings, and they said that that easement works only for the first issuance of the token. But then, because there are some companies who are issuing the supply of the token with several session of fundraising, and the FINMA say if there are subsequent fundraising and issuance of token, then the issuer need to be affiliated to an SRO. So basically, this easement has been a bit corrected with the practice of the FINMA. So we can move on the next slide. And now for the utility tokens, securities regulation. So it is interesting for you to know that if you're qualified as a utility token, the FINMA will not treat this token as a security, provided that it gives access to a service. As I said, this is the definition of the utility token, but in addition, it actually be used this way at the point of issue. So that's what is written in the guidelines of the FINMA. So we had some difficulties at the beginning to understand what does it mean at the point of issue. But basically what it means is that the FINMA, as I said before, wanted to prevent those scam about we will develop this magnificent platform for you, and there was nothing behind. And so they say now what you need to do, you need to demonstrate that you have a platform which is functional at the time of the issuance of the token. You can move on the next slide. And basically this is interesting because it means that if you are using the fund that you're raising, let's say on a private sale, to develop your platform, then it's not because it's a utility token for accessing a service. So you're using the fund that the contributor has paid your token to develop the platform. So it's an investment. And this will be likely requalified by the FINMA as a security, and will be treated as a security if the people were using the fund to develop the platform. And now it's a big question, and at the time of the guidelines of the FINMA, I think it's the first time that ever happened. The FINMA had made some round session, one in Geneva and one in Zurich, And we were there and we were asking some questions because they say, yeah, you mentioned that the platform need to be functional. So the thing is that there are some tokens who has 4 services, and let's assume there is 2 services and the 2 other one are not functional at the time of the issuance. How would you qualify whether it's a utility or not? And they had already this answer. They said, but we are focusing on the main services. So what is the main services you're giving access to your token? And then if you have nice to have, basically we will have our discussionary view on it, but this is a little less important. But we've practiced this with the several rulings, and each time the FINMA is very risk averse. And actually, we had one client saying we have 4 of the services, and there was one who was not developed, and we told them, yeah, but maybe it's good to put them in the white paper as a research and development for a future stage. But they were insisting because they already talk about their community and their contributors about these services specifically. So we went to the FINMA and say, yeah, so we have the 3 main services, and the last one is just a nice to have. And basically the FINMA come back and say, yeah, but we cannot exclude that it is not a utility token if it's not functional at the time of the issuance. And so we'd say to the client, so now you have two things. You make it functional before the issuance, or you put it in the research and development on your white paper, and they actually developed it. And the thing is that the FINMA, what you need to understand, does not have the resource, even the knowledge to know whether your platform is functional or not. Okay, so what they're saying that if at the time of the issuance the platform is functional, we will qualify your token as a utility and not treat it as a security. Okay, then it's the liability of the issuer to make it happen somehow. So basically, the only case that we will see that it's if a holder of a token want to access to the service the first day of the issuance and he cannot access to the service, but then he will complain to the FINMA, and the FINMA can come back to the issuer saying, yeah, but basically it was not functional at the time of the issuance. You see what I mean? Okay, so I think we can move to the next slide. And one thing also is important. There are in fundraising, when you do an ICO, you have the private sale and then you have the public sale. And in a private sale, some of our clients say, yeah, but okay, we cannot use the money to develop the platform, but can we use it for other things? And that's what has been clarified also with a Federal Council report, that the funds that are raised can be used, but for the operational activity of the company, for paying the employee, for paying the premises, for paying the lawyers, or whatever it is. So basically that can be done for marketing purposes as well, but and to improve the platform and not to develop them. So that has been also clarified. I think we can move on to the next slide. And now that was a part of the securities regulation side. So I hope it is clear, and although you can ask question and we will answer to this. For the AML regulation, so the guidelines of FINMA mention that utility tokens are not subject to AML regulations, provided that the main functionality is access to a service that has non-financial application. So if you have access to a financial services, then you will likely apply the AML regulation. But for non-financial application, you don't need to have a regulation. But as I said, a utility token might be sometimes an hybrid, and it's not sometimes, it's mostly every time the case. When you use a utility token into a platform, you enter for the services and you use it as a mean of payment to access to the service. So most of the utility token are also a mean of payment. So how do you say, do you apply ML or you don't apply? And you can move on to the next slide. And there is on the ordinance on the AML that the fact that if the function of the payment is an accessory services compared to the access to the services of the token, then the token will not constitute a mean of payment. And we also tested this one. So at the time, we were always asking for a ruling FINMA of a utility token and say, yes, indeed, we can use the token to pay the services as well, but it's only an accessory services. It's really a secondary services compare a subordinate importance compared to the primary services. But FINMA always take no risk. They say, indeed, we understand, but for us, it's not accessory enough, and the payment token definition should be qualified. The token should be qualified as a payment token. But in the end, this problematic of AML regulation is not. Is quite easy, because even if the guidelines say that AML does not apply to utility token, basically you will always need to apply AML regulation. Why? Because when you're raising funds through the issuance of a token, then you will receive cryptocurrency into wallet, and as you want to use it to pay the premises, your employee, your lawyer, whatever it is, then basically you need to cash out into a bank account. And I guess that in your jurisdiction, it's quite hard to open a bank account for companies who are in the fintech world and in cryptocurrencies. So in Switzerland, it is also complicated, but there are banks with whom we are working, and it's private banks who are allowing cryptocurrency. If you have a KYC AML, it means the know your customer, you know who is your counterpart, and also if there is a company who is doing what we call a forensic analysis on the wallet of the buyer, so you can see that the coin are not tainted, and they are not going through the dark web. And you also have some corroboration with a video call with all the contributors to clear a bit the money. And if the money is not cleared, so the issuer cannot accept them. And today, for Swiss bank, it's business as usual. They only accept fiat money, but they need to have this filter of KYC AML regulation on top of it. So, and that would apply also to utility token as well. So that's important to keep in mind. One thing is also important. We thought maybe that there is no pure utility token, and actually we did have one who give access with the token to the services of the platform, but all the services was only available with fiat money. And the FINMA confirmed, so this is a pure utility and not a payment token. But even though, as I said, you will need to, if you want to cash out the money, you will need to apply KYC AML as well. So we can move to the next slide. And asset tokens, so this is a securities token I discussed. I think we will discuss this more on more detail. So we had this bonds, shares, and the one who are with an economic function such as royalties and any kind of token that give a claim against the issuers. And FINMA generally qualify asset token as uncertificated securities to the extent that they are standardized and suitable for mass trading. One thing maybe I can add, you remember I mentioned the last definition regarding the hard asset. So NFTs, usually it's a title of ownership on a JPEG, and I think that in the United States you have also this kind of definition of a title of ownership on a JPEG. So you're saying like a pen or a book, but you have in the US what you call the Howey test, meaning that it depends also how you're marketing it. So if you're saying, please come and invest into our NFTs and to the moon, or this kind of qualification, it might requalify your token, which is just a title of ownership, into a securities token. So you need to be careful on that as well. I think we can move on to the next slide. So for asset tokens, the FINMA guidelines say there is no AML regulation applicable to securities token. But again, best practice, we will apply AML for the cash out. I think we can move on the next slide as well. So in Switzerland, if you want to issue a token, you can obtain a ruling from FINMA on the qualification of token. You have also a tax ruling for the proceed of the ICO, and you can have a bank account for the cash out in Swiss bank account, provided that you have a financial intermediary services who is providing this KYC, AML process, and the source of fund process. And also, you need to have an accounting firm specializing in accounting of tokens, because it's quite also not a straightforward process on that. So that was for the FINMA guidelines, and now we can touch base on the tokenization. So as I mentioned, the DLT Act has created a new type of negotiable instrument, what we call ledger-based securities, in French, which is droit valeur inscrit. So it's Article 973D, which says that a ledger-based security is a right that is registered in a securities ledger and may be exercised and transferred to other only via the securities ledger. And when we always talk about tokenization, one should understand that a tokenization is the operation whereby a digital token registered in a distributor register are associated with a digital asset or a right, like a share. Let's take the example of the share, in such way that you cannot be transferred, the one cannot be transferred without the others. So like a glue, the token is the share and it's transferred with the one, and it's written in the securities ledger. So as I mentioned, the DLT Act has amended a lot of laws. I don't want to repeat myself, so we can move on the next slide. And the thing is that the Code of Obligation now explicitly recognize the issuance of token in the distributed ledger base. So if you have a token that is linked to a right and is registered in the distributed ledger, you have a ledger-based security, okay? And the Code of Obligation, as I said, it was amended by the DLT Act, has also clarified one thing that back in time was an issue, because under Swiss law, the assignment of a claim is require a written form to be valid. And to assign a share of a company, basically, you need to have a written form. And how do you do that in the blockchain? So it was difficult to say, yeah, but we can trade the shares into a secondary market. And people said, no, because you are assigning a claim without a written assignment. And basically, now the law with the DLT Act has been clarified and saying if the token is in the disputed ledger and is following the disputed ledger, it is transferred by the disputed ledger, and you need to also have some predefined modalities, what we call the tokenization terms, which is embedded in the smart contract of the token. Then you can transfer the token without any written assignment, because we can follow in the blockchain the line of transfer of the token. So issuance of a ledger-based security and transfer is clarified in the Code of Obligation. Now, trading venues, and that my colleague will touch base on that. The DLT Act has created a new license for regulated venues that specialize in DLT instrument, and clarified also the possibility to obtain a securities firm license to operate an organization trading facility for ledger-based securities. And this is what the company Tokenisation in Geneva has obtained this year. I think we can move on the next slide. So what are the benefits of a share tokenization? I'm focusing now on the share because it's one of the easiest one. Basically, if you're incorporating company now today in Switzerland, you will be able to tokenize the share of the company. And I don't know if you're doing M&A transaction, but usually when you do this, there's a lot of problematic regarding the shares, whether people have assigned the share there, or where are the shares, if they have been pledged, and so forth and so on. And what is good with the DLT or distributed ledger is that you are 100% sure that the purchaser of the tokenized share is the legal owner of these shares by proving his access with his private key. Okay, so it's facilitated this kind of share register problematic that we have in M&A transaction as of today. Now, for unlisted private company, it's a huge opportunity because you can access to a new innovative investment models, because some people want to do an IPO, but IPO are very expensive. There's a lot of different intermediaries involved, and it has a lot of cost. But now you can just open your share capital to investors via different channel and an online trading platform. This is so very, I think, an easy way to financing your company, or to an innovative way and a new way. And the other benefit is that you can reduce your costs, operational costs, financial costs, because you have less intermediaries. And also you have a faster transaction execution, and you can automate a lot of different tasks using smart contracts. I think we can move on to the next. And so the question is, which kind of company can tokenize their shares? So basically it's a limited by share companies, and also partnership limited by shares, but not what we call the limited liability company. Why? Because under Swiss law, when you have a limited liability company, at each time you are assigning a share to another shareholder, you need to register this shareholder to the commercial register. So I'll let you imagine how difficult it would be to trade such kind of tokens for a limited liability company. So that's the way it happens. And now you can tokenize the shares, and also what we call a participant rights certificate, which are shares without voting rights. And you need also to know that it's a reversible process, because a company who is tokenizing their share can revert back to non-tokenized shares. So it's not like an end of the story. I think we can move on to the next slide. And as I said, the Capital Market Technology Association has provided some standard for the issuance of tokens, because now you have in the law the right to issue a securities, a ledger-based securities. You can transfer it, but now you need to have the proper documentation to do that. And if any kind of lawyer are doing its own documentation, it's a bit of a chaos. So the capital market technology has set some standards, legal standards and technical standards. You can use also a smart contract of the CMTA which comply with all the requirements of Swiss law. So you don't need to invent something. It's also publicly available, and it's actually never been so easy to issue a securities token today. I think we can move on the next slide. So you can also obtain a certification. That's what you want to know. So if you're following the standards, and you also have some legal expert and technical expert recognized by CMTA who can validate that you had followed the correct standards to issue your tokens, and this has some kind of value maybe for investors saying, but is your business legit? Say, yeah, we have a certification and we have a FINMA ruling, so it gives you a lot of credit on that. And now for the requirement and recommendation of the CMTA for tokenization of shares, if you can move on to the next slide. Basically, the article of association of the company needs to provide that the share can be issued in the form of a ledger-based security, and you need to exclude also the right of a shareholder to request the physical delivery of certificates. Indeed, because if they request it, you will not be able to do so. Then the issuer article of association also must not restrict the transferability of shares, because you want to have it easily traded in the secondary market. Now you also have a decision of the board who allows the tokenization of the shares, and it needs to be documented. And you need to have those tokenization terms that is embedded in a smart contract with the token, which explains the modalities such as the transfer, the pledge, and so the process in case you're losing the loss of your keys, and what is the process to issue a new token. Maybe you can move on to the next slide, because what is important is that as I said, the CMTA is providing you a smart contract which is fully compliant with Swiss law and have some specific requirement, also a burn function, a kill switch function. So because under Swiss law, when you lose a share, you can go to the tribunal and reissue a new share, provided the one is deleted. So you need to have a smart contract that can allow also the fact that a token can be burned or and replaced by another one, because the supply, it's the share capital of the company. And then at the end of the day, you also need to identify the shareholder, because it's not sufficient just to have a ledger-based security in the blockchain. But at the end of the day, if you want to have the right to the dividend, then you need to do this KYC AML and to the source of fund on who is your shareholder. So you need to have what we call the share register of the company. So this is not on the blockchain. This is a document which is internal to the company, where you say, okay, who are you? Please provide me with your private key. Show me and prove me that you are the right shareholder of the company and that you want to exercise your right for the general meeting and for the dividend. And when the KYC AML will be cleared, then you will be registered to the share register of the company. And I think that's the last slide. Yeah, that's what I just explained. So in a nutshell, if you want to understand everything, is that the regulatory framework by law, you can issue a securities by law easily, and you can transfer it easily. And then you have Swiss standard providing set of rules which are publicly available to comply with all these rules and just issue this type of token, a securities token. And now what is a world premiere, when you have this token issued, you can trade them to a regulated security market open to retail investors and not only to institutional. So now I will hand up the discussion to Alexander for the prospectus requirement.
Yes, hi everyone. I'm Alexander Dibokar, in charge of Swiss financial regulation here at OA Legal. Before I start, I will just quickly answer to the two questions we have. Concretely, the first one is after Switzerland, do we have another country having a similar regulation or likely to introduce regulations for tokenization? Maybe just to explain in Switzerland how it has been done concretely from a purely Swiss regulatory perspective, we added DLT-based securities to the regulation, meaning you would have a regulation applying to securities. Now the regulation applies also to DLT-based securities. So concretely, we didn't really change the law. We just added the DLT-based securities, such as tokenized shares, tokenized bonds. So we didn't really change the regulation. We just accepted, I mean, the regulator and the Swiss authorities accepted that shares can be exchanged or issued via tokens. So this way to regulate tokenization, we are not aware of another jurisdiction. Why? Because it's really a simple way to regulate the activity. So if you see in Europe, there are some discussions and some EU regulation, for instance, but it's much more cumbersome because the regulators are thinking what can they add at the additional regulation. You know that BTC, Bitcoin, all kind of currencies, and also blockchain generally is some leads to some questions from the regulators. So here we don't have that questions. It was handled with 5 years ago. So concretely, we are not aware of another jurisdiction where we would have really a clear view on what we need to do. Of course, there are discussions among most jurisdictions, but I think we started quite earlier in Switzerland for once. Second question: how long does it take to have a license as a Swiss trading venue, and how much does it cost? You would need to be at least a securities firm. What is a securities firm? We call it sometimes securities dealer or broker dealer. Concretely, you can buy and sell securities in your name for clients, but you can buy and sell in your name. You know, you need a minimum share capital of 1.5 million Swiss francs. Okay, 1.5 million. So this is the minimum capital requirement, and I would say that you should count at least 1 year of process with FINMA, the Swiss regulator. Bearing in mind that we mentioned Taurus. I don't know if there are representatives of Taurus listening, but we saw that it took more than 1 year for Taurus to obtain such license, and it was quite a lengthy process for Taurus. So we can think that it would, in practice, take more than 1 year, and that's what is a bit cumbersome, the timing. I hope I have answered to the question. If not, you can complete the question or make a comment. Let me just speak a few minutes about the requirements in terms of prospectus, documentation, and also terms of regulation. First, as a general principle, as in most jurisdictions, anyone who would like to make a public offer to sell shares or other kinds of securities, or to trade such securities on the platform, we need to publish a prospectus prior to such issuance or listing. This is quite common. We have some exceptions. For instance, if the issuance is below 8 million Swiss francs, you would not need a complete prospectus. You could use, let's say, simplified prospectus. We can move to the next slide. Thank you. Concretely, we have a quite detailed list of the content requirements, and you find almost a template of prospectus in the Financial Services Ordinance. So we know exactly what needs to be mentioned in the prospectus. It has to be submitted to what we call in French organe de contrôle, an official supervisory body. It would take between 10 business days and 20 business days for such supervisory body to confirm that the prospectus is complete, consistent, and clear. It would cost around 4,000 Swiss francs for this process. We can move on. Hopefully, we have the Capital Markets Technology Association, usually called in Switzerland CMTA, which provides for a prospectus template for the offering of tokenized shares in Switzerland. This is very useful for lawyers, but also for issuers of tokenized shares. Why? Because it reduces significantly the contractual and regulatory risk, because the standard has been validated not only by a major law firm here in Switzerland, but by other law firms, members of the CMTA, but also by Swissquote, who is also a trading venue in Switzerland and a very active member by the CMTA. So we have really, let's say, the market side, the trading venue, and the lawyers who worked together to have the standard. So concretely, we have a template of prospectus, quite detailed, very specific, also on IT and IT security matters. And you can use this, actually, it's free of charge on the website of CMTA. So you almost don't need a lawyer. Of course, you have to pay attention that you fulfill correctly the documents, but I think really in practice, you could almost fulfill this on your own. So it really reduces all the legal costs. And it means that concretely, you can have your prospectus quite quickly ready, submitted to the supervisory body. You can issue your token, and then you have already a secondary market available. So we don't have all the standards ready. For instance, we don't have a standard for bonds yet, but CMTA is really working on it since 2023. So we hope that we'll have this standard this year. At OA Legal, we have been working on this for many years. So we have also our own template. And we think also now working on actively managed certificates. Those are structured products. And concretely, we will not have a full prospectus dedicated to the tokenization. We'll just add a two-page addendum explaining that the ownership of those certificates could be certified by a token. So I'm summarizing here, but we have already such template. Also, this is again discussed among the financial lawyers here in Switzerland. So interestingly, I think we'll have more and more standards, but the CMTA is really working a lot to help the issuers issuing security tokens. We can move to the next slide. Thank you. So as mentioned by Fabian, the DLT Act, so-called DLT Act, created a new license for regulated venues specialized in DLT-based securities. And this is what Taurus has been using, the DLT-based trading system. You can move to slide 32. Thank you. What is the consequence is by adding the DLT-based securities into the Swiss regulation, the issuance, the exchange of the secondary market would be subject to all Swiss regulation, which is not too complicated. Of course, we have some market abuse rules, basically insider information restrictions and market manipulation. So FINMA, the Swiss regulator, would pay attention to this. Concretely, how it would happen is the Swiss trading venue, whereas Taurus, Swiss Quote, one other, would have suspicion about the specific trade due to the quantity, timing, persons involved, any facts that they could have. They would first ask the investor or the participants to clarify the trade. And if they still have some doubts, they would inform FINMA, saying, okay, we have a doubt. FINMA would step in. There would be an enforcement proceeding, potentially, or a pre-enforcement proceeding, meaning FINMA would ask questions directly to the company or the investor involved, and potentially can also inform the criminal prosecution authorities at the federal level. So it's a federal crime to do some market manipulation, insider information. In practice, there are not that many cases, hopefully, because Switzerland is a financial jurisdiction. So the participants, of course, they need to comply with this. If they do not comply, they would be they could not anymore work in the financial sector. So FINMA would just prevent them and they would just not work anymore for financial institutions. Or so we have quite strict rules of enforcement. And of course, in an area of fintech where sometimes, especially in tokens or coins, investors would say that we don't understand the big moves, why the price are that high or that down. Here in the securities regulated markets, it can happen, but we'd have everything really monitored at the level of the trading venue, the DLT trading venue, and with FINMA stepping in if there is an issue. So as a financial lawyer, I believe this is really an added value for the investors, of course, and it doesn't have that many costs because it is not the issuer or the participant investor who would have this. This is the cost at the level of the exchange completely. We can move to the next slide. This is a topic we have regularly to deal with. It's cross-border. Why? Because Switzerland is a small country. We don't have that many inhabitants. And concretely, when you are in Switzerland, you can incorporate a company. It's not complicated. We don't need that many persons. You can then externalize a service level agreement with the IT team abroad, the marketing team abroad. So you can delegate whatever you want within the company or in. But concretely, you need to find investors. Some of them could be in Switzerland, as Fabian mentioned, asset managers, high net worth individuals, family offices. But of course, you need also to open. You don't want to market this only towards Swiss people. So this would depend on other jurisdictions, as you know, meaning all the jurisdictions would have a specific requirement. Concretely, we will not market actively abroad, whether in Europe or in the US, without having a legal opinion issued by a legal advisor, a local legal advisor. But this now has been dealt with at the level of the secondary market. Usually, we are the issuers deciding about 4, 5, 6, or 10 jurisdictions. Okay, mostly in Europe, also sometimes outside the European Union. But now we don't have to deal with this. Why? Because we have the secondary markets who has exactly the same questions from its regulator, from its board of directors. So they would accept some investors from specific countries, again, without doing an active marketing in those countries, but they would accept such specific investors from specific countries, for instance, in Europe. And then it's an analysis on a case-by-case basis. But again, you don't need to do it anymore as issuer or as platform issuing tokens on the primary market. Why? Because we could rely on the cross-border regulation of the secondary market. We can move to the next slide. Concretely, and to summarize maybe and to conclude, what we believe here at OA Legal is that really this DLT Act and adding the DLT-based securities into the Swiss regulation really would have a positive effect and ensure more transparency towards investors, more stability in the fintech ecosystem, and also would ensure an equal treatment among investors. And this is something which is sometimes difficult to find in the non-regulated area. So it is not only useful for investors, but also issuers of security tokens, platforms issuing tokens on the primary market. We really believe that having a look at what is now available now in 2024 in Switzerland would be useful. And we have regularly the question, do we go in other jurisdictions? I don't want to quote all jurisdictions, but usually it's in Europe and sometimes in Asia, Singapore also, but we don't have that many countries open really to such issuances. So we regularly have the question, we would compare Switzerland to some other jurisdictions. So again, I think the Swiss regulatory regime is quite straightforward, quite simple actually. And I think, again, we don't need to have all the team, because Switzerland, again, is small, so we never move teams from abroad to Switzerland. So we find a way to have one operating company or one holding company in Switzerland, and we reduce the human resources required in Switzerland. It's quite flexible in Switzerland because we have many holding companies, many multinational companies which are really part of the activity in Switzerland, and a lot of activities abroad, because again, we are a small country with a limited number of inhabitants, so it's fine not to have everything in Switzerland. But we really think that yeah, it was a great progress the last years. I see that now we are coming to the end. We still have a couple of minutes to answer the questions, what we will do. So I will take them in the chronological order. Does the business security need to already have an ID number for its security? So from a regulatory and legal perspective, it's not required, but in practice, we would have an ISIN. But for a market, let's say for business reason, why? Because if you have an ISIN, it means that an asset manager in Switzerland, a portfolio manager, a bank, could put this in its portfolio and could also be remunerated to be custodian, to be a manager. So concretely, we recommend from a business perspective to have an ISIN, and you could get an ISIN from the 6 Swiss exchange, even actually if you are not traded on the secondary market, even if you don't have tokens, of course. So concretely, it would not be too difficult to obtain an ISIN, but it's not required as such by the regulation. So second question, can we walk through the process of initial tokenized issuance of Sukuk or bond? Sukuk, if I'm not mistaken, is we had this, Fabian, you remember? So it's without interest, I think. Okay, so concretely, it's not that different from issuing shares. Why? we don't have the question of voting, but we have the question of interest. So concretely, the token would be a representation of your ownership in the bond. So the process is quite the same as for the shares. We don't have yet a CMTA standard, but concretely, what we would do is we would have a Swiss company, okay? There is no minimum capital requirement. We would need to understand the business purpose of the company, the use of proceeds, because we issue bonds, it's to achieve some milestones, some goal. Once we understand that there will be a Swiss corporation, we understand the business purpose, we understand the use of needs, we would draft the prospectus, and we could issue, actually, without any kind of authorization, the bonds in Switzerland. Then, if we want to list them, in parallel, we would discuss with a trading venue. There is not only a tourist, actually, there is other ones, and we would discuss with them whether there would be any interest to list, to have them on the secondary market. But the process is quite simple, and if you are interested, we can even show you maybe by email let's say the 4 steps. But it's quite straightforward, and it would take all in all not more than 6 weeks, something like this. For the secondary market, it can take a couple of weeks more, but it's not too complicated. In terms of timing, I cannot go into too much details because it's already we don't want to keep you longer than what was expected, so it's 1 hour. I don't know if you want to add something to conclude, maybe.
I think Dan will take from here. Thank you all for your listening.
Yeah, I just wanted to say thank you so much to both of you for your time today. It's an incredibly insightful and interesting presentation, a very important topic, I think, as well. So thank you very much to our audience for being with us today. We really appreciate it. You can see Fabian and Alexander's email address and contact information on your screen. We'll be sending you a follow-up with their bios, with their email addresses, so please do get in touch for any further information. We really do encourage that. But thank you very much once again. Thank you to our wonderful panel, Fabian and Alexander. We hope we can see you again soon. But for now, I hope you have a lovely rest of your day. Thank you.
Thank you all. Thank you all participants. Thank you, Dan.
Thank you.